Hi, good afternoon.
Hi, good afternoon.
Welcome to join us on Lisa's webinar today. In this video, we'll focus on property, especially those common disputes and problems that almost every landlord and tenant may experience at some point. We will cover some very common issues and resolutions in private renting sector and also in commercial lease sector. This video is for you. If yourself is letting a property or thinking about doing so, or unsure about how to, or unsure about the rules, or if you're a tenant who's facing rent arrear or disrepair issues, or you're just purely interested in this sector, want to know the procedure, the rules, this is a video for you. So drop us a line, drop us a comment if you're watching it, and tag the people you know who may be interested, and we'll reply to you.
Hi, so my name is Evveline Law. I'm a solicitor at Lisa's Law, and I have here with me Yitong, who is a trainee solicitor at Lisa's Law. We are both experienced in the property area of law, and we have dealt with extensively on property matter, such as rent arrear disputes, any of the forfeiture of lease, surrender of lease, possession, eviction of claim, things like that. We have done it extensively. We are both defended both tenants and landlords themselves, so we are able to help you.
So if you're facing any of these issues, situations, or if you know that someone is, like I said earlier, please tag and share and like it, and leave your comments. We'll try to get back to you. If you have any more questions, then contact us by our phone or our WeChat or WhatsApp, on Facebook, and our email, then we'll try to come back to you. So, yes. Right, so if we, today we're going to talk mainly about things that Evveline and I already covered. We can see on the slides now, commercial lease, private sector, we'll focus on these sectors. And issues we've covered this. A review, okay, so the procedure will change and had changed now, and the procedure and rules for notices are different. So we need to look at those, and what you as a tenant or landlord will look out for. Then we'll talk about it as well. Also, Coronavirus Act and the pandemic itself has a huge impact on our lives. So also on the rules and procedures, we'll look at them as well. Today I'll focus on private renting sectors. We can see different type of tenancy agreements. We will review we'll review different type of the tenancies. First, assured short-hold tenancy and non-assured tenancy, letting to organization, or if it's a lodger, then there will be excluded tenancy. Just to go into the main one, the most common type of tenancy is a short-hold tenancy. We'll talk mainly on this one. It's very important when landlord and tenant enter into a tenancy. It's very important for you to understand what's the feature of your tenancy, and then you know what's the rule and procedure you follow. So what is a short-hold tenancy? Basically AST, we call it. So it's the most common type in the UK, and especially England nowadays. It's introduced by the Housing Act 1988, and now has become a default type. The previous slides we have showed you. And you can check all these criteria if that fits the ATS one. So the rent is between 250 and 100,000 per year. And the tenants are people rather than organization, such as you let into a company, that will be the company let. Or the property will be the tenant's main home, or the landlord does not live in the same property as the tenant. So you understand your type, if it's AST or if it is company let. So that means you letting to a company or even a charity, that's a company let. And the one that we said before, if your landlords live in the same roof, under the same roof, then that's totally different from this. So now you know that the rules will be different, obligations will be different, and a different approach in your action. So next we can have a quick scan of these issues. So normally it's So normally we will come across rent arrear, disrepair, subletting. That is actually subletting without consent, and ending a tenancy with no fault. Normally it wouldn't be a problem, but during coronavirus period and also after, due to employment issues and employment issue or people reducing the hours or even local restrictions, we'll have problem. We see people cannot move around, so we'll have sometimes problem with ending a tenancy even though there's no fault. And rent deposit, this I've said before, I think to a lot of clients of mine, especially for landlord, put that rent deposit in that scheme. So when you have to give that notice to a tenant, then you wouldn't be losing out or get any counter claim. So those are the issues are rising nowadays. We see a lot of those problems. First, we will try to encourage parties to really communicate, have some effective communications, and talk to your tenant, talk to your landlord about your problems, and also try to negotiate rationally about your payment plan and about, okay, you can't pay anymore. Do you want to vacate or move out at some point? Talk to them. Or, you can look at this problem with different mind, with insurance in mind. Your landlord may have some insurance or yourself that can cover that disrepair that the landlord or tenant cannot repair during the lockdown or after due to various reasons. And also, very important to always follow the correct rules and procedures. Understand the current restriction. This one I'm going into a little bit more detail. We're going to talk about that, and Evveline will talk about commercial as well, the time ban as well. And then make sure you make a decision and you get the advice. Running up to actions. Right, so we'll look at more on the notices, Section 21 and Section 8, that we usually give under AST, a short hold tenancy. So these two types of tenancy notice. Section 21 is for no fault, like I said earlier. So you have that tenancy and then now the term's finished. So you want to end that. Or there's nothing wrong with it, we just want to end it. Okay, so no hearing required, you can see that, and not available to any other form of tenancy. So company let, you don't use this, or resident landlord, you don't use this, only for this AST. Usually the notice period is 2 months, but due to the pandemic now we have some different time limit, so we're going to look at that. Section 8 notice, this is for basically some contentious matters. So you have something that you're not happy about rent arrear, that's the most seen problem. Basically, it's mandatory grounds. So we have many grounds for Section 8 notice to be given. So make sure you look at all the grounds, see if it's mandatory. That means you are more likely, or the judge must give you, must make a decision, must make possession order for you if you're a landlord, or discretionary grounds. So 1917 is all these, so different breaches, subletting, or maintenance problem, repair problems. So you need to look carefully which grounds are your problem, or you may have various grounds or multiple grounds. So look for that. Usual notice period depending on the problem, basically. So you have weeks notice or months. Usually 2 months if it's rent arrear. I think that's weeks is minimum, but 2 months usually. If it's a month, like periodic tenancy. and a hearing is required. Okay, so this one we talked about earlier about common law tenancy. This one you give notice to quit instead of section 21 or section 8. This is a notice to quit. So basically the other two will not apply. So company rent greater than 100K, resident landlord, you use this notice. Right, the next one, requirements. So what's the requirements? It's very clear on my lists. So basically EPC, landlord and tenant are very familiar with EPC, safety certificate if it's required. And this information is basically a government guideline. You need to keep that. Deposit protection and valid notice period. We'll look at the period of time, like I said again. Section 8, tenants at fault, you need to give your legal grounds, like the grounds I said earlier, and notice period updated, focus on that. Counterclaim, yes, this one you need to think, okay, especially for tenant, if you're a tenant and then you think, okay, my landlord served me a notice saying I did something wrong. However, I do have a disrepair issue, which is the landlord's obligation. Then that is your counterclaim. That's your reason, to get your money back or have some reason to stay. Then you need to file that counterclaim. So update, we see the change recently. Please have a look at the slides. Before March 26th, 2 weeks. That's severe rare delay. And also in between March and August, 3 months. And now we all know it changed to 6 months if rent arrear is less than 6 months. Or 4 weeks if rent arrear is quite substantial, 6 months or over. And other grounds, quite lots going on, right? So we're focusing on serious antisocial behavior. I think there's a lot during lockdown. People are not, not abiding to the rules. So 4 weeks. So this one actually changed back to the previous one. Now it's 4 weeks. And also 8, 10, and 11. Mostly 8 is mandatory grounds. So 6 months, okay, but 4 weeks if you have serious arrears. And 17, false statement, so a dishonest problem, so 2 weeks going back to the original one. Okay. Update in section 21 notice, quite clear. 2 months before, 3 months in between March and August, and now after August, that's 6 months after 29th August. Yeah, so you need to look out for that. And also a timeline, right. So now here, landlord must start court proceeding within 3 to 4 months after serving the notice. What does that mean? Show you this sophisticated timeline, right? So basically, if you serve the notice or you get notice before 26th of March, you have 4 months. After that period notice runs out, you have 4 months to bring your claim. Okay, so between 26th March and to 28th of August, you serve notice at that time. Then you have 3 months after your period notice period expires. But after 29th of August, you serve your notice after that time. Then now you have 4 months to do that application to issue a claim. So must do that if that's what you choose to do within the time limit. So really need to look at because 3-4 months is quite a long time, so keep a track on that. And valid notice must have the current notice period and also comply with the rules of service. This one is also very important as well. Court will look at how you serve your notice. Don't just chuck it in at the door. Make sure you get the right professional service to them. Right, current approach. We do have some updates, as you see, from 21st of September this year, the court started to deal with eviction application again. So we actually see a lot of notice and letters about reactivation of cases, or okay, your case is back on track and the judge will look at it. So now it's going back to track again. But they do have a lot of cases to look at, so bear in mind that. So landlord applied for possession order before 3rd of August. They can now reactivate the claim. So for tenant, you need to look out and think if you are in serious rent arrear or if you have some other issues, make sure that you get yourself heard. So tenant shall check the claim particulars and make counterclaim. I have mentioned before, and I've just said again. So check the grounds. If you receive the claim form for tenant, check the grounds and check if they're valid, if they are true, and if you have anything to add, anything to claim, then yeah, make sure you file that on time. Yeah.
It's interesting, this one.
Yeah, again, tenant or landlord may take notes of this. So what landlord might have done, had applied for possession order, claim and defense forms, get them ready. Okay, so claim for the claimant, and the tenant will do the defense if you do have some grounds. And reactivation notice, yeah, the one we said earlier as well. So you will get a notice from the court if the court say, okay, we start to look at a case, and you will. If you don't, then you have to file your notice. Then you'll get another notice of review. The court will tell you, okay, this day, this time, I want both parties to be ready, including telephone hearing. So they may have a judge look at the case and they may contact you if you wish to proceed. Or if you have settled, that's all the merrier. Notice possession hearing, okay, so if you haven't settled before that, then this is the time you get a notice of hearing. So you will get a device and prepare for that. Right. Okay. Like I said, the common disputes in this sector already covered. If you're still unsure what type of tenancy agreement you have, your rights and obligations, you're unsure, or what kind of notice you should give, the timeline, I know it's a lot of complication in the timeline, or type of tenancy suitable, then you can seek professional legal advice on that. But do bear in mind, as landlord or tenant, your obligations and rights do not change during pandemic, after pandemic. Yeah, you still need to pay the rent, you still need to keep your place maintained, or keep your place repaired for your tenant. These do not change. And next one, I'll let Evveline talk about commercial property.
Yep, so I'm going to go into more detail on commercial property. So as you can see, I'm going to cover the common disputes in commercial property. So as you can see, there's a list of common disputes, and usually it will be the ones listed here. But today I'm going to cover mostly rent arrears, lease forfeitures, and section 25 and 26 notice, which is lease renewal. So moving on, let's look at lease renewal. So that will be grounds for termination or renewal of the lease. So usually you'll be looking at section 25 and section 26 notice for commercial property. And let's go on to this. So for commercial property, it's slightly different from residential property. There is such a thing called security of tenure, which is under section 24 of the Landlord and Tenant Act 1954. So what does this mean? This usually grants you an automatic right as a tenant to continue your tenancy, and the landlord doesn't have a right to terminate it. The only way they could terminate it is either to serve a section 25 notice or the tenant to serve section 26 notice. So some cases you will see the leases that have a special clause in there that exclude this operation of 1954 Act. It is uncommon and sometimes common as well, because some landlords do prefer to have certainty, and they do prefer to have like a fresh new lease whereby the terms can be negotiated again, and they can regain possession for whatever reason they wanted, maybe. So let's move on from this. So for termination of such ground in commercial property, there are similar to residential, whereby there are two methods, which is under the common law as well as the statutory method. For common law, there are two methods, and that is by serving a tenant notice to quit, or by way of surrender and forfeiture. While for statutory method, it will be under Section 25 up to Section 29. And what is the difference between a Section 25 and Section 26? Section 25, like I said previously, is usually initiated by the landlord, while Section 26 is initiated by the tenant. So Section 25 allows the landlord to usually grant a new lease or vacate the tenant. And again, time is sensitive in this sense. You must serve it not more than 12 months or less than 6 months before the contractual expiry date. But please bear in mind, this can't be served if a tenant serves you a Section 26 notice. So time is of essence in this sense. So the landlord can serve it on two bases, a hostile basis or non-hostile basis. Non-hostile basis means they are happy to renew the tenancy and there's nothing needed, okay? But hostile grounds will be the grounds that you see in the middle here, which are A to G. And for Section 25 notice, once it's served on the tenant, there's no need for the tenant to counterclaim, okay, to serve a counter notice. For Section 26, it is the same. The tenant will serve the Section 26 notice, and if the landlord opposes, this is the different thing, the landlord must serve within 2 months from the date of which the Section 26 is served. And because after that, if you don't meet the timeline, you will fail to have a claim against it. The tenant must state, obviously, the rationale of the termination and whether they want to renew the lease. And again, this cannot be served if a landlord has served a Section 25 notice. And you must always specify the proposed commencement date for a tenant if you want to renew the new lease. So let's move on. So again, timeline is of essence here. If you look at this chart here, you can see if a notice is served on the 30th of March, and the date of expiry is actually on 30th of March 2021, you will see that it must be a gap of 12 months, and that is the earliest period you can actually serve the notice. It's the same for Section 26, but the only difference will be the proposed commencement date must be 12 months gap from the day you serve the notice. And here you will see a timeline for surveys in the sense when is the earliest that a landlord can terminate or renew the lease. So there must be a 6 months gap in between. Similarly, again, for Section 26, there must be a 6 months gap between the start date or the expiry date. So moving on here. So what happens now during the COVID-19 situation? Is there any difference to renewal? Landlord, this is more on landlord actually, because you need to know that the market currently, as we all know, is not good at the moment. So if you haven't served your Section 25 notice, we would advise that you better off holding off the surveys and extend the period. At least you know there's a tenant in place and you have rent to collect, okay? But however, if you have already served the Section 25 notice or the tenant has served a Section 26 notice, maybe you want to consider having a quick agreement, because you might be afraid that the rent might fall even further, since not many people are opting to have a commercial lease at the moment. So that is our advice on COVID-19 at the moment. As for the next one, it will be on forfeiture. So what is forfeiture? Forfeiture is actually a landlord's contractual right, and they must exercise their right to elect such right to bring the lease to an end. But the reason that you can actually exercise such right, a specific event must actually trigger such right. So what sort of specific event that we're looking at? So it's usually here, the grounds for forfeiture. It will usually be for things like failure of repairing your property, or tenants' insolvency, or things like non-payment of rent. Okay. So for forfeiture, they are actually two methods that you have to take notice. Because for forfeiture of rent, you can't actually serve a Section 146, and that is the only exception. But for any other breaches in the lease, let's just say failure to repair or anything else, you will have to serve a Section 146 notice on such breach to forfeit the lease. Okay. However, do remember you always have to allow time for the tenant to remedy any of such breach. Okay. For forfeiture to take place, it's either upon the expiry date of Section 146 notice, or upon the landlord, obviously, if it's a rent arrear, is the day that if you, within 14 or 21 days, usually, if you don't pay the lease, then there is automatic right for the landlord to actually forfeit the lease. As for here, so the two methods of forfeiture that we have here in the UK is peaceable re-entry or by way of court proceeding. So for peaceable re-entry, it's usually where it's feasible, where the landlord can actually physically re-enter the property, because sometimes there are properties that are 24 hours guarded, or things like warehouse is difficult because you might be afraid that the tenant might counter-sue you for trespassing. So that is when a court proceeding will be a better way to forfeit the lease. As for the next one, okay, so procedure-wise, for Section 146 notice, please remember, landlord has to serve a Section 146 notice. It must refer to a relevant covenant, specify the breach, state what is needed to be done to remedy the breach, and obviously remember, you must give them time to remedy such breach, because the court will take that into account. But do note that no matter what sort of forfeiture, the tenant can always apply for relief from the court, and this can only be granted by the court and can't be agreed by parties. Next one. Okay, waiver. This is a very complex thing in forfeiture, because waiver do occur when the landlord, if you know the tenant is in breach and you does something that recognizes the lease continue to exist, or you communicate to the tenant, then you will deem to be automatically waived your right to actually raise a forfeiture claim. So bear in mind, forfeiture, there are two types. One is a continuing breach, things like disrepair, they are continuing. But rent arrears is not a continuing breach, it's a once and for all breach. In that case, if you communicate with the tenant or in any way you write to the tenant, then you might actually lose your right to raise a forfeiture claim. So essentially, for the landlord, you need to know how soon, whether you know there's a breach, and whether you treat it as a continuing breach, and will you accidentally have waived your right to actually forfeit the lease, is very, very important. So in forfeiture, let's take a look at COVID-19 update again. There is this Coronavirus Act in 2020, which prevents any forfeiture claim between 26th of March to 31st of December. As before, the landlord has the right to forfeiture for any breaches of the lease. However, now, obviously, everything has been stayed. We are foreseeing that this might actually go further than 31st of December, but we will give you an update further if there's any changes here. As for rent arrears, so this is very common now during the pandemic situation. Usually for non-payment of rent, there is this list of methods where you can actually ask your tenant to pay rent. Usually if it's for a commercial lease, you have guarantor. You obviously take a rent deposit, but things like that has been pretty difficult because rent deposit pandemic has been on for months now. So usually your rent deposit would be 3 months. By now, if you can't get any more money from the tenant, this is what you have to do now. So what can you do during this situation? The best is to have first a general contingency plan. Take a look at your cash flow, talk to your accountant, talk to your lawyer, see whether there's any way to resolve this. And as well, always pay attention to the government schemes. So the government has came out with many different schemes, things like 25,000 for small businesses, any of the loans. You should actually pay attention. If you need the link, do message us. I can send you the link. The next one would be the insurance. Obviously, speak to your insurance broker, talk to your insurance company, see whether there's any way they could actually assist you in this. And the third, that's the common one where we really urge everyone to do it, which is have an open dialogue with your landlord. Similarly to residential property, always speak to your landlord or your tenant. Maybe they could actually give you a rent concession, maybe to reduce the rent waiver for a few months. That would actually still keep your business afloat. So COVID-19 update on commercial property. So for commercial property, usually you have another method, which is the commercial rent arrears recovery, whereby you can actually recover your rent. But again, this has been held on hold until the 31st of December. So now, unless the rent has been in arrear for 366 days, you can't actually use this method anymore to chase the tenant for paying. And some tenants might actually be cheeky enough. They will just make sure that they meet the 366 days, so they pay up to the rent where they owe you for 366 days, and you can't actually do anything for that. And the last one here is, so the other one would be Corporate Insolvency and Governance Act. So usually you can actually set your demand or winding up petition. But now, again, this has been obviously put on hold up to the 31st of December. It sort of restricts you, prevents you from collecting debt in this case, but I guess we are all in this together for the pandemic, so it's a very difficult time at the moment, but we can't actually do much. But do note that you still have your rights as a landlord and tenant. It's just delayed at the moment. Yeah. Okay. So this is enough talking from us. Let's just answer your questions.
We do have some questions coming in.
Okay.
We do have our further contact info if you need it. Yeah.
Okay. I think we can see here. Okay. Yes. So this is
my landlord demanded also. Okay, this question from Carrie. Yeah. I'm guessing, Carrie, this is
it legal?
Private rented.
Yeah.
Yeah. So my landlord demanded check-in and check-out fee is illegal at all. I thought
it is
search fee had been banned. Have you? Yeah. So Evveline, would you?
Yeah. So for this check-in and check-out fee at the moment, it is actually banned. I'm not sure why your landlord is actually demanding this. So I think if you ever, I'm pretty sure there's a claim here going on here. So if you need legal advice, do contact us. This is definitely something that we can look into, because it is under the law that the check-in and check-out fee at the moment it's not legal. And the next one would be it's a Dick. This is from Dickie. So I'm a landlord and rented my apartment out. Should I buy insurance for my tenants, or they can help covering the costs?
Okay, so first, what type of insurance are you talking about? Are you talking about building insurance, or content insurance, or landlord insurance? can give us a little bit more detail. Usually we would, I think what I've seen landlords quite happily to purchase this landlord insurance to cover personal injury and things like that, and it wouldn't cost too much, depending on the apartment. But normally it wouldn't cost too much to get landlord insurance. And for building insurance, I think usually landlords should have that building insurance.
Yeah.
Covering costs, I think this is a contractual problem. So it's more based on what you agree with the tenant, and if you want to, or if
it's usually stated. It depends. It usually stated in your contract with your tenant.
Yeah. But then you can get a quote and see if it's reasonable. Depending on the type of insurance, still, I'm thinking, what kind of insurance is this? But if it's landlord insurance, I think it is landlords.
Most very, because he's asking from a landlord perspective.
So recently, I do have question from our clients. I think some people are company let, as I said, and they don't know which notice to serve. And then I think this one that we talk about is notice to quit.
Yeah.
So you do have that notice to quit. And as far as I know, the Act doesn't really affect that. So you can still serve your notice based on your contract, or normally it would be, if it's a periodic, it will be based on if your periodic payment is 1 month, then it will be 1 month. If it's half year, then it will be half year notice. So that would not change.
Yeah, I think I have some of the few common issue here as well, whether serve a Section 146 notice. So as of now, Section 146 notice, you can actually serve even during the pandemic. But obviously, the only thing that you can't actually serve at the moment is under the common law, which is the rent arrears. So that's the reason that you can't actually serve such notice. But Section 146, any other breaches, feel free to contact us. You can actually serve a notice at the moment. So yeah, Section 146 for forfeiture is still applicable. We have another question coming from Chingnam Chan. Okay. My boiler broke down. I think it was my fault. Okay. Very nice of you to admit fault.
Not too early.
Yeah. But am I or the landlord responsible to fix it? Okay, boiler.
This sounds like
should be a resi.
Should be a residential renting. First, I think maybe get a technician to get a gas engineer to check what sort of problem, and if that's your. Sometimes it look like your fault, but maybe it's a precondition.
It's just landlord has the duty to actually get it serviced every year if they want to rent it out to tenants.
Yeah.
So
check if you have that safety, or
I think you have to check whether you are actually at fault at breaking it, because usually for boiler it is under the landlord's under the contract that the landlord will fix boilers. But again, it really depends, because it seems like you did admit that it was your fault for breaking the boiler. So, but yeah, if not, usually it would be the landlord's duty to sort of fix the boiler.
Yeah, so we don't know what's the fault and how do you mean it was your fault. I think we need to look at it and check if there's any precondition of the boiler already, and if the landlord does not do the check every year, service every year.
It's actually their duty to do it.
So we need to look at that first, and then see if there's any insurance, if it's covered by anything. So maybe you don't, you have some deal with the landlord.
Sometimes, I think, like my personal experience, there are sometimes boilers that are in disrepair. But when they tell the landlord it is actually under warranty, and the landlord is more than happy to actually get it fixed.
Yeah, there you go.
Yeah,
so don't panic first. Check it first.
Check with your landlord first.
Yeah. So
there's the next question. I think, do you want to follow up, Tiffany?
Then Dickie, hello again. Right. So Dickie said, I'm not too sure. I heard there are many types of insurance. Do you know which one is the best yet? We are not in the position to advise insurance type, I'm afraid, Dickie. But you can do some research, or
Because I think we don't even know what sort of insurance are you talking about. Like we previously said, because are you trying to buy a content insurance, a building insurance? What sort of insurance are you looking at? Because like Yitong just mentioned, there are many types of insurance. Are you trying to insure your tenants' contents? In the property? Or it's just a building insurance that you're looking for?
Exactly. I think, Dickie, if that tenant has specific requirements, say, okay, I have a really expensive piano here, I want to insure that, then I think more or less they will need to contribute a little bit towards that.
Usually content insurance is by the tenant themselves, it's not actually by the landlord.
Yeah, and you have landlord insurance, for example, I live in your house and rent your flat, and then I broke my arm for some reason here and there, then you might need that landlord insurance to cover that personal injury.
Next one, can I sublet my room to my friend? Yes, Sabrina. The landlord is my family, but I don't want to let them know about the subletting. We didn't sign any contract. The landlord is my family. I'm not too sure what's this. The landlord is
sounds like private renting.
Private renting. Because I think the landlord is my family, so her family is the landlord.
Yeah, I think the legal proprietor, who is that first? And then do you have the authority to sublet?
I think usually sublet there would be a clause in the tenancy agreement whereby you have to take a look at it.
Contract.
If with the parents, or presume it's it's difficult because your question is not phrased in full. We didn't sign. Sabrina, do you mind if you rephrase your question? Because
I think it depends. You don't have a contract with your landlord, and your landlord is your family. So, but then you don't want to let them know about this. They oppose it. Have they specifically said no subletting, or you have to sublet? Then let me know. And if you have some special reason you have to let a room to your friends, then you may, okay, you don't want them to know. We want to know a little bit more about this, I think. Sabrina, you need to be a little bit more specific. Yeah. Even though there's no written contract. There's no written contract.
But there might be an implied.
And also oral contract, still contract.
So number 6 would be Kaishre. What do I do when landlord don't return? Oh, this is a very, very common dispute on deposit.
I think you need to, first you need to know the reason why. The reason why. Do you have an agent? If you don't, probably ask the landlord why. Because we can't say from what you said now, did you break any clause? Is there
any disrepair, or did you breach any of your because if so, yes, obviously the landlord. Usually, if nothing is wrong, the land, everything's perfect, leave it as it is. You do have an obligation to put your deposit into a deposit scheme, and then they must definitely give you back the money.
If there's nothing wrong, there's no reason to hold.
If not, you can if you actually choose, if there's no reason to hold back your deposit, then if you apply for a small claim on, I don't know how much it is, but I doubt it's going to be a big sum. So apply to small claim, you will have the right to get either double or to triple your deposit money. That it really depends on, is there any reason to hold your deposit from the landlord?
That's true. Also with the deposit, I just want to say a little bit more. Now, a lot of landlords do actually very good put that deposit in. But don't forget to give that notice or confirmation to your tenant. So after 30 days, after 30 days, you will be held liable to some compensation if you don't actually give that confirmation to your tenant. But I do know a lot of landlords do that, but forget to give confirmation. Don't forget that. But if you do forget, or if you actually didn't have the time to put that deposit in the protection scheme, what can you do? But you can actually discharge that liability by giving the deposit back to the tenant and say, this, your deposit, I return to you. So basically, you're not holding it, but not put in the scheme. You're not holding any deposit. So that's another way to look at it.
Oh, okay.
We have another question from Dicky.
Brilliant, Dicky. Wrote it better now. Okay, let's see. My tenant is concerned with the safety. Okay, like scared of being broken. Okay, this will usually be the insurance for public. What's that called? Public trespassing or something.
Yeah, trespass. Yeah. Still, why is a tenant concerned with safety? Is your property have any records of being broken in? So I think we need a little bit more information because this is not a usual request.
This is a fairly unusual. But anyway, if your tenant is concerned of being broken in, I think what you're looking for will be the insurance for contents then, because I think your tenant is more worried about the contents that is being stolen in the property. And usually, yes, if it's content insurance, if most of the stuff in there is your tenant's own stuff, let's just say it's unfurnished or it is partly furnished, then yes, you can actually ask them to pay, because content insurance is not usually the landlord's duty to insure. It's usually up to the tenant whether you want to buy a content insurance, because when you're renting a property, the landlord don't usually insure your contents. It's up to you to purchase your own content insurance.
And the reason why they they worry so much about it, about their own safety, or are they in any trouble? Maybe you should get that cleared up first.
Okay.
We do have some more questions to answer, but don't forget to drop us any more questions or any other areas or related areas you want us to cover. For example, the company letter. I know I don't have much time today to talk about it. So we can actually cover a little bit more of that maybe in next. We do have question on what's that question?
Oh, sorry. About mortgage holiday. There are people who ask for a commercial property, whether there is a mortgage holiday, and whether it's extended as well. So mortgage holiday at the moment it's extended. It's not extended for 3 months for commercial property. Okay. So, but most lender now has they will actually agree to defer such mortgage repayment. So do speak to your mortgage advisor. So Yitong, is there anything else?
I can't see question now. We do have some clients also ask about lodger. Okay, does this act of this notice period and this all extension apply to lodger? I think from what I see, it does not apply. But you really need to look at what is the definition of lodger, basically, and make sure that you know that it's actually a lodger, not some tenant, just but with a resident landlord. So that's totally different. So lodger is sharing a lot of common space with you, not just a kitchen. But it's a lot of other common space with you as well. So it's quite the line is quite fine. But make sure you check with good advice and see.
Because they have different rights compared to AST itself.
Yeah, different right. A little bit less right, but you still need to make sure that they're not just a tenant under your same room and you're a resident landlord, but they actually, before you give that notice or before you do that eviction, check all the facts. Yeah, check your agreement. Sometimes you think you forget about your agreement, but then the lodger or the tenant piece of paper saying tenancy agreement. Then that's the time you probably think, okay, yes, we do have a tenancy. We do have a tenancy.
So I have usual question on things like commercial property statutory demands. So because of the new rules, some people think that they can't actually serve a statutory demand. It is true, but however, if it's something that you're served pre 27th of April this year, then it will still actually proceed. But please bear in mind, the courts are working in a less hour and they are all doing it from home, so there might be delay from their side. But if not, sorry to say, anything after 27th of April, you might have to wait to 31st of December again until you can serve that statutory demand from a commercial tenant.
Just look out for more extensions. Look out for update and extension, because it could be in commercial sector, it could be
it can be, because 31st of December is still not a conclusive one. Honestly, due to the pandemic, practitioner has been discussing that it might actually go all the way to February at the moment. But obviously, don't take our words, because the government hasn't actually come up with anything concrete on this. So we just have to wait and see on this.
Any more questions you can put in the comment box. We'll see it.